You are before the court today for an advice of rights or an initial hearing. If you do not understand the English language and need an interpreter, please let the jail know that now. If you are under the influence of any alcohol or drugs that will affect your ability to understand these proceedings, please also tell the jailers that. If you suffer from a mental illness or disability that will affect your ability to understand these proceedings, please let the jail know. When you appear in front of the judge assigned to your case, you will be asked several questions. If charges have not yet been filed, the prosecutor's office will be given 72 hours, excluding weekends and holidays, to determine what, if any, criminal charges will be filed against you. If charges have been filed, you will be read those charges and the statutes defining those charges. I will read the penalty ranges for the possible charges now. If you're convicted of a Class C misdemeanor, the possible penalty is anywhere from nothing up to 60 days in jail and up to a $500 fine. If you are convicted of a Class B misdemeanor, the possible penalty is anywhere from nothing up to 180 days in jail and up to a $1,000 fine. If you are convicted of a Class A misdemeanor, the possible penalty is anywhere from nothing up to 1 year in jail and up to a $5,000 fine. If you are convicted of a Level 6 felony, the advisory sentence is 1 year. The penalty range is 6 months to 2.5 years and up to a $10,000 fine. If you are convicted of a Level 5 felony, the advisory sentence is 3 years with a penalty range of 1 to 6 years and up to a $10,000 fine. If you are convicted of a Level 4 felony, the advisory sentence is 6 years with a penalty range of 2 to 12 years and up to a $10,000 fine. If you are convicted of a Level 3 felony, the advisory sentence is 9 years with a penalty range of 3 to 16 years and up to a $10,000 fine. If you are convicted of a Level 2 felony, the advisory sentence is 17.5 years with a penalty range of 10 to 30 years and up to a $10,000 fine. If you are convicted of a Level 1 felony, not a child molesting charge, the advisory sentence is 30 years with a penalty range of 20 to 40 years and up to a $10,000 fine. If you are convicted of a Level 1 felony child molesting charge, the advisory sentence is 30 years with a penalty range of 20 to 50 years and up to a $10,000 fine. If you are convicted of murder, the advisory sentence is 55 years with a penalty range of 45 to 65 years and up to a $10,000 fine. You may also face certain sentence enhancements. If you're convicted of a vehicular substance offense charged against you, and you were found to be an habitual vehicular substance offender, meaning you have 2 or 3 prior vehicular substance offense convictions, you will be sentenced for the criminal offense, and the court will add additional time for being an habitual vehicular substance offender. The additional time for which you will be sentenced will be between 1 and 8 years. If the prosecutor has filed an habitual offender enhancement against you, contending you have been convicted of 2 or more prior unrelated felony offenses, you may be found to be an habitual offender. If you are convicted of 1 or more of the felony charges now filed against you, you will be sentenced for the felony offense, and the court will add time to your sentence for being an habitual offender. If you're convicted of a Level 5 or 6 felony, the additional period of time your underlying sentence may be enhanced for being an habitual offender is anywhere from 2 to 6 years. If you're convicted of a Level 1, 2, 3, or 4 felony, the additional period of time for which your sentence may be enhanced for being an habitual offender is anywhere from 6 to 20 years. If you were released from jail on a pending criminal charge and you are now charged with another criminal offense that was alleged to have been committed while you were released, the sentence on the newer charge is required to be served after the sentence on the first charge. If you are charged with a criminal offense that is alleged to have been committed while you were on probation and the court finds that you violated your probation, the sentence on the new charge is required to be served after any sentence that is imposed as a result of your probation violation. If you are charged with more than one criminal offense, the sentences on those charges may be served concurrently or at the same time, or they may be served consecutively or one after the other. Let's talk about your right to a lawyer. You have the right to hire and be represented by an attorney in this case. You also have the right to proceed without an attorney if you so desire. If you wish to hire your own attorney, you must do so within 10 days if you are charged with only misdemeanors, or within 20 days if you are charged with a felony. There are deadlines for filing motions and raising defenses, and if those deadlines are missed, the legal issues and defenses that could have been raised will be waived or given up. If you cannot afford to hire an attorney, the court may appoint one for you at little or no cost to you. If you wish to have a public defender appointed, you will be asked questions to determine if you qualify for such an appointment. The right to a lawyer is one of the most important rights you have. Lawyers are educated, trained, and experienced in the law, and will know much more about these proceedings than you could ever know. The lawyer can provide advice to you about those things that must be proved before you can be convicted, the strength and weaknesses of the evidence against you, and the defenses that may be available to you. The lawyer can also investigate the case, cross-examine the witnesses, and present evidence that is favorable to you if you wish to do that. The lawyer can also talk to the prosecutor on your behalf and attempt to resolve the case without a trial. You should not proceed without the advice and assistance of a lawyer unless you decide after careful consideration that you do not need a lawyer's help. The court strongly urges you to obtain the help of a lawyer. If you decide to proceed without a lawyer, you will be held to the same standards and requirements that defendants who do have a lawyer are held. A preliminary plea of not guilty will be entered on your behalf today. It will become a formal plea of not guilty 10 days from today if you are charged with only a misdemeanor, and 20 days from today if you are charged with a felony offense. Defendants in a criminal prosecution have certain constitutional rights guaranteed to them by the United States and Indiana constitutions. You have the right to a speedy public trial by jury in the county in which the offenses were allegedly committed. If you are charged with a felony offense, your case will automatically be set for a jury trial. If you wish to exercise your right to a jury trial and you are charged with only misdemeanor offenses, you must file a written demand for a jury trial. That written demand must be filed no later than 10 days before your first scheduled trial date. If you fail to file a written demand or you file it late, you give up your right to a jury trial. You will be presumed innocent unless and until the state proves you guilty beyond a reasonable doubt. You have the right to face all witnesses against you, to see, hear, question, and cross-examine those witnesses. You have the right to require witnesses to be present at any hearing to testify in your behalf, and at your request, subpoenas will be issued by the court requiring those witnesses to appear. You have the right to be heard in your own defense at any hearing or trial concerning the charges against you. You also have the right to remain silent. You cannot be required to give any testimony or make any statement against yourself to anyone. Anything you say may be used against you. You will be asked if you understand these rights when you appear in front of the judge. If you have any questions about your rights, please ask the court to explain them to you. You have the right to bail unless you are charged with murder and the proof against you is strong. To be released from custody, you must meet certain conditions set by the court. If you do not understand the conditions set for you, please ask the court to explain those conditions to you. Your future hearings will also be set by the court. You are responsible for knowing the times and dates of any future hearings. If you fail to appear for those future hearings, that failure to appear will result in a warrant being issued for your arrest. If your address or phone number changes during the time your case is pending, you must notify the court in writing within 2 business days. If you have any questions, please make sure you bring those to the attention of the judge.